The envelope was thick. That was the first thing I noticed, the weight of it in my hand when I pulled it from the mailbox on a Tuesday morning. Certified mail, return receipt, the HOA's logo in the upper left corner. I opened it on my porch and I read the first page and then the second, and then I sat down on the front steps because my legs had done something unexpected. The letter said I was in violation of the driveway surface standards as outlined in the community guidelines, that my driveway had been in violation for an estimated 90 days, and that the accumulated fines at $150 per day came to $13,500. $13,500 for a driveway. My driveway, which I had repaved 2 years ago at my own expense, which met every specification in the guidelines as I understood them, which had been inspected and approved by the city when the work was done. I sat on those steps for a long time. Then I went inside and I pulled out the folder I kept in my filing cabinet, the one I had put together when I bought the house 9 years ago, the one that contained every document the title company had given me at closing. I was looking for one specific page. When I found it, I read it carefully. Then I made a phone call, not to the HOA, not to a lawyer, to the County Property Records Office, because what I had found on that page suggested that the HOA might not have the authority they believed they had over my driveway, and I needed to know if I was reading it correctly. I was reading it correctly. And what the County Records Office confirmed for me that Tuesday morning ended a $13,500 fine, removed my property from the HOA's jurisdiction entirely on that specific question, and produced a legal outcome that the board president has described in a community meeting I attended 6 months later as the most embarrassing situation of her governance career. Stay with me. My name is Henry Paulson, and I have owned my home at 6 Clearbrook Lane for 9 years. I am not an attorney, not an engineer, not a contractor of any kind. I am a high school history teacher, and I have been a history teacher for 21 years, which means I know how to read primary source documents, how to trace the origin of a claim to its foundational evidence, and how to recognize when a stated authority does not match the underlying record. These skills are more useful in homeownership disputes than most people expect. The document that ended the HOA's case against me was a piece of paper I had received at closing 9 years ago and had filed without reading carefully, because at closing you receive a stack of documents and you sign where you are told to sign, and you trust that the title company has done its job. When I finally read it carefully on that Tuesday morning, it told me something the HOA had either not known or had chosen to ignore, and it told me with the specific authority of a recorded instrument in the county property records that had been sitting there for 47 years waiting for someone to look at it. The development of Clearbrook Estates had been built in 2 phases. The first phase, which included my street, had been developed in 1977 by a builder named Hartwell Construction. The second phase, which was the larger section on the eastern side of the development and which contained most of the homes, had been developed in 1984 by a different builder under a separate subdivision plat. The HOA had been established with the second phase in 1984, and its governing documents, the Declaration of Covenants, Conditions, and Restrictions, applied to the properties included in that subdivision plat. The properties in the first phase, the 1977 section, had been incorporated into the HOA's service area at some point, meaning they paid dues and received the common area maintenance services. But the legal question of whether the 1984 CC and RS actually applied to the 1977 properties as a matter of recorded covenant was a question that had apparently never been carefully examined. The document I found in my closing folder was the original 1977 deed restriction document for my property, recorded in the county records as part of the Hartwell Construction subdivision. It established certain basic restrictions on the property, standard 1970s residential restrictions about use type, setbacks, and structural limitations. What it did not do was incorporate the Clearbrook Estates HOA's CC and RS. It predated them by 7 years, and the 1984 CC and RS, when I obtained a copy from the County Records Office that Tuesday morning and read them with the attention of a man whose financial situation had just acquired urgency, defined the properties subject to their covenants by reference to the 1984 subdivision plat, which did not include my lot number or my street. My property was in the 1977 section. My lot number appeared in the Hartwell Construction subdivision plat. It did not appear in the 1984 Clearbrook Estates subdivision plat. The 1984 CC and RS applied to properties in the 1984 plat. My property was not in the 1984 plat. I am a history teacher. I understand what primary source documents say when they say it plainly. What these documents said plainly was that the specific covenant provisions in the 1984 CC and RS, including the driveway surface standards and the fine schedule that had produced my $13,500 notice, might not legally apply to my property. Might not. I was careful about the word might because I was not a lawyer and I was reading legal documents outside my professional training, and the difference between what a document appears to say and what it legally means requires expertise I did not have. But the appearance was clear enough to warrant the phone call. The County Property Records Office confirmed that my lot was recorded under the 1977 Hartwell Construction subdivision plat and that the 1984 Clearbrook Estates subdivision plat did not include my lot. The records officer I spoke with, a woman named Janet, who had been working in that office for 22 years, said she could not give me legal advice, but could confirm the recorded facts, which she did. She also mentioned, without editorializing, that questions about covenant applicability to pre-existing subdivisions incorporated into later HOAs came up occasionally, and that they typically required an attorney to sort out definitively. I called an attorney that afternoon. His name was George Altman, and he had been practicing real estate and property law in our county for 30 years. I described the situation and the documents I had found. He asked me to scan and email them before our conversation went further. I scanned and emailed the 1977 deed restriction document, the relevant pages of the 1984 CC and RS, and the two subdivision plat maps side by side. George called me back in 40 minutes. He said, "Henry, where did you find this?" I told him it was in my closing folder from 9 years ago. He was quiet for a moment. Then he said, "Do you understand what this means?" I told him I thought I did, but wanted to hear him say it. He said that based on his preliminary review, the 1984 CC and RS did not appear to bind my property as a matter of recorded covenant, that the HOA might have a service relationship with my property through dues payment and common area access, but that the enforcement authority, the ability to levy fines and require compliance with the CC and RS, derived from the covenant documents, and if my property was not within the covenant's defined scope, that enforcement authority likely did not exist. He said he needed to do a full title search and a complete analysis before being certain, but that his preliminary view was that the fine was not legally supportable. I asked him how long the full analysis would take. He said a week, maybe 10 days. I asked what I should do in the meantime. He said to acknowledge receipt of the fine notice to the HOA in writing, state that I was reviewing the matter with counsel, and make no payment or admission. I wrote the acknowledgement letter that evening. It was 3 sentences: receipt acknowledged, matter under review with counsel, no response to the substance should be expected before the review was complete. I sent it by certified mail the following morning. George called me 11 days later. His analysis was complete, and it was what his preliminary review had suggested. The 1984 Clearbrook Estates CC and RS defined the subject properties by reference to the recorded subdivision plat filed in 1984, which did not include my lot or the other lots on Clearbrook Lane and 2 adjacent streets that had been part of the original 1977 Hartwell construction development. 9 properties in total. All 9 had been paying HOA dues for years. None of them appeared to be legally bound by the 1984 CC and RS as a matter of recorded covenant. The HOA had been collecting dues from and attempting to enforce its standards against 9 properties that the covenant documents did not legally reach. The dues question and the enforcement question were legally separate, George explained. The dues might be supportable through service agreement principles even absent a binding covenant. But the fine authority, the ability to levy fines for violations of the CC and RS, derived specifically from the covenant and its enforcement provisions. If my property was not within the covenant, the HOA had no authority to fine me under it. The $13,500 fine was, in George's opinion, legally unenforceable. He also identified something I had not asked about, but that turned out to matter. The 1977 deed restriction document for my property contained its own driveway provision, which addressed the surface material in terms that were standard for 1977 residential covenants. My driveway surface, which was concrete with a brushed finish, was fully compliant with the 1977 restriction. Whatever the HOA's 1984 standards said about driveway surfaces, and whether or not those standards applied to my driveway met the applicable recorded restriction for my property and had for the entire 9 years I had owned the house. George drafted the response letter to the HOA. It was 15 pages. It presented the title analysis, the subdivision plat comparison, the recorded covenant documents, and the legal conclusion that the 1984 CC and RS did not bind my property as a matter of recorded covenant, and that the HOA's enforcement authority, including the fine schedule, did not legally apply to my lot. It noted that the driveway surface met the applicable 1977 deed restriction. It demanded immediate withdrawal of the fine notice, a formal acknowledgement that my property was not subject to enforcement under the 1984 CC and RS, and a written statement of the basis on which dues had been collected from my property for 9 years, given the covenant applicability question. He sent it to the HOA's attorney by email and certified mail simultaneously. The HOA president at the time was a woman named Sandra Whitmore, who had been in the role for 3 years and who ran the association with the organized efficiency of someone who had come from a compliance background and who believed that the proper application of documented rules was both a professional and a moral obligation. She had signed the original fine notice. She had done so in the genuine belief that her authority to do so was established and that the violation was documented. What she had not done, what apparently no president before her had done in the 26 years since the 1984 development had informally absorbed the 1977 properties, was look at the foundational covenant documents and confirm that they actually reached the older properties. George told me later that the HOA's attorney, when he received the letter, had immediately pulled the covenant documents and the subdivision plats and had called Sandra within the hour. George said that based on the subsequent communications, it was clear that the attorney had confirmed our analysis and that the conversation with Sandra had been a difficult one for both of them. The difficulty was not just the fine, which was unenforceable and would have to be withdrawn. The difficulty was the implication for all 9 properties and for the HOA's relationship with them going back to the beginning. The fine notice was formally withdrawn 11 days after George sent his letter. The withdrawal letter from the HOA's attorney was brief and said only that the association was withdrawing the notice of violation and the associated fine schedule pending a review of the applicable covenant documentation. It did not acknowledge the substance of George's analysis. George said that was what he had expected and that the substance would be addressed in the next phase. The next phase was a community meeting that Sandra called 6 weeks after the withdrawal. It was the meeting she would later describe as the most embarrassing of her governance career. She presented the situation honestly, which I respected. She explained that a review of the covenant documents and subdivision plat records had identified a question about the applicability of the 1984 CC and RS to 9 properties in the original 1977 section of the development, that this question had been raised by one of those property owners in response to a fine notice, and that the HOA's attorney had confirmed the question was legitimate and required resolution. She said the HOA was engaging a title company to perform a formal survey of the issue, and that the results would be shared with the affected property owners and the full membership. She did not say my name. She did not need to. Everyone in the room who knew the neighborhood knew which property owner had raised the question and how. The The title survey confirmed George's analysis. All 9 properties in the 1977 section were outside the defined scope of the 1984 CC and RS. The HOA's attorney presented 3 options to the board for addressing this. The first was to formalize the service relationship through a separate agreement with each of the 9 properties that would provide for dues and common area access without covenant enforcement. The second was to pursue a formal amendment to the CC and RS to include the 9 properties, which would require consent from all affected property owners and from a supermajority of the existing HOA membership. The third was to leave the situation as clarified, with the 9 properties outside the covenant's enforcement scope and with dues arrangements to be individually negotiated. 7 of the 9 affected property owners chose the first option, a formal service agreement covering dues and common area access without covenant enforcement authority. 1 chose to leave the HOA entirely and negotiated a release from any service relationship. I chose a version of the first option, but with a modification that George had suggested, which was that the service agreement explicitly documented the applicable restrictions on my property as the 1977 deed restriction, not the 1984 CC and RS, so that there would be no future ambiguity about which standard applied to my driveway or anything else on my lot. Sandra signed my service agreement personally. She had been professional throughout the resolution process, and I had no personal animus toward her. She had applied what she believed was her authority to a violation she believed was real. The problem was not her application of the rules. The problem was that the rules, as recorded in the county's property records, did not reach my property. Nobody had checked. The records had been there for 47 years. They had been sitting in the county records office and in my closing folder and in the HOA's own founding documents. And for 26 years, nobody had looked at them with the attention the situation required. I'm a history teacher. My students sometimes ask why primary sources matter, why it is not sufficient to rely on what subsequent accounts say about them. I tell them that primary sources are the record from which all subsequent accounts derive, and that when an account conflicts with the primary source is what determines the truth of the matter. The 1984 CC and RS said what they said. The 1977 subdivision plat said what it said. The recorded instruments in the county property records said what they said. $13,500 said what it said. And when the primary sources were actually read, they resolved the question completely. My driveway is concrete with a brushed finish. It has been concrete with a brushed finish for the 9 years I have owned the house. It meets the 1977 deed restriction that applies to my property. It always has. The records always said so. All it took was reading them. Thumbnail text ===. They fined me $13,500 for my driveway. A 47-year-old document ended their entire case.